what are the three things do you think that an litigating lawyer should do to become an arbitration lawyer?
I think the only thing that people need to be prepared is it can't be bureaucratic and it can't be like a government job कि आज arbitration का कुछ आ गया है तो मैं मंडे तक वेट करूँगा, आज तो फ्राइडे इवनिंग है, because your timeline is running whether it's a Friday or a Saturday or a Sunday, unlike your courts where your timeline you get those breaks of but you don't get your break in courts if you have a 30-day period calculation and all. But if you tell the court that I want 10 days and today is a Friday, sometimes the court adjusts. लिमिटेशन में आपके वीकेंड नहीं काउंट होते हैं, आपके वीकेंड मतलब एक्सक्लूड नहीं होते हैं, वो भी काउंट होते हैं. बट आप a lot of times you know that there's a condonation of delay. You can tell the court that the client was unavailable on a Saturday, Sunday. These things come into play. So I'm not, by no stretch of imagination, I'm saying that your litigation period is going to be just your 5 days, but it's more flexible because almost all the times, except when it's barred under law, you get a condonation. I have seen matters where I've got time taken against me 5 times. But in an arbitration, your schedule is very, very rigid. Very, very rigid. If you have a hearing at 6 p.m. on a Friday and you have time till Monday, you have time till Monday. You can't be like, oh, yeah, but today was my weekend, I had to do this. So I feel it's more fast-paced. If you're in an active arbitration, you should be ready that anything can happen at any time. Anything can happen at any time. You can be getting ready to go to a party and suddenly, or maybe just for a family dinner, and you will suddenly know that there's an application which is filed and is listed at 10 a.m. tomorrow morning for hearing. So even if it's not listed for hearing, there are requests made in that application, along with that application which you want to contest, and you want to immediately respond to that email. So I feel A, you should be ready to be working at all hours because it's more fast-paced. B, I feel arbitration is always good as a team effort because the bigger the arbitration, the more hands you need. So if you're not a team player, please don't think about being a good arbitration lawyer. If you want chest thumping and grandstanding, then please pursue courts where you get a lot of chances to do this. So you need to be a very good team player. I also feel that you should have keen interest in arbitration because an MCIA arbitration is going to be very different from a DIAC arbitration. A DIAC arbitration is going to be very different from an ICC arbitration. So unless you're really interested and you keep reading about the rules under these arbitration, it's not going to be very helpful because it's like a closed chamber. In a court, you can Google and get to know what's happening in a particular case. You can log on to Manupatra, you can get a series of judgments. There are certain arbitral awards which have started getting published from 2019, but majorly this is a grey area. They are also not very, I'd say, elaborate about what happens because they redact it. I was recently attending a conference in Bombay where Justice G.S. Patel said that these awards should be made published because when we are hearing a 34 petition, we should know what happened in the tribunal. We just get those 40-50 pages knowing what the arbitral tribunal has said. So also I feel that without interest you can never be a good arbitration lawyer because it's so small but it's so wide. It's so vast. How it happens here is very different from how it happens abroad. You can't just say that I'm a domestic arbitration lawyer. You have to do domestic, international, ad hoc, institutional. So it's like a sea within a sea. So unless there's interest, there's full devotion and dedication, there's that willingness to do everything at odd hours, and there is that spirit to be a team player, it's not a good idea to be an arbitration lawyer.